can't stand for very long. That's the problem. Too many arthritis as a result of too many years of running. Thank you. It's always wonderful to be back in Concord. I had my first job here as a lawyer and met my wife here, so I have fond feelings for Concord. It's no secret that there's a lot of pressure on us to get our students ready for practice because of changing conditions out there and difficult economic circumstances, and that's all good, but I hope that as we develop and think about new ways of getting them ready for practice, that we don't lose sight of at least one old standby, which I have happily discovered teaches a number of different skills, and that's the client advice letter. One of the pleasant discoveries I've made during the last almost 6 years now of teaching at Vermont Law School has been that you get a great deal of bang for the buck with the client advice letter because it offers a chance not only to practice the traditional analytical skills, the thinking like a lawyer stuff, but it also enables students, in fact, in many cases, puts them in the role of counselor for the first time, a role that they're typically unfamiliar with, and some have trouble adjusting to, but it forces them into that role that they're going to play over and over again as lawyers. And I think skills is the operative word here. I should provide some context. We teach we have a 3-semester writing program. Starts with Legal Writing 1, which is actually taught by our law librarians who do the research component of it, and 18 third-year students who are Dean's Fellows, supervised by a couple of faculty members for the Legal Writing 1. And Legal Writing 2 is the first time that the course, a writing course, is taught exclusively by professors. The letter that I'm going to talk about comes in the context of Legal Writing 2. It's an opportunity for each legal writing faculty member to use an area of substantive expertise of his or hers to teach writing. And I happen to use amateur sports law. And we have a variety. They're really all over the map, from state constitutional law to environmental health to amateur sports law, a number of other natural resources. But the assignments are fairly standardized. The students are required to do three major writing assignments. Usually they are a predictive memo, an advocacy memo, which is often a motion for summary judgment memorandum, and then either a judicial opinion or a law clerk's bench memo to a judge. And then 2 skills exercises. One of those is a 10-minute oral argument, usually on the motion for summary judgment issue. And the other is anything you want. And I use the client advice letter for that. Now, I wish I could say that that decision was a result of some great inspiration, but it really was not. It was quite utilitarian at the beginning. I knew from my own practice that writing letters was a standard part of practice, something I wasn't prepared to do when I got out of law school. It gave the students another opportunity to write, and our students certainly needed every opportunity to write that they could get. We emphasize environmental law, hence we get a large number of science majors who are not accustomed to writing. For many of them, indenting the first word in a paragraph was a foreign concept. So as a result, giving them every opportunity to write was absolutely necessary. And the other beautiful thing is, picking up on Mary's point about a client letter, is that it can be done quickly. It doesn't take a great deal of time. But the revelation part came after seeing the many happy consequences of this assignment, not the least of which, as I said, was forcing the students to play the role of counselor. They were accustomed to playing the role of litigator, or litigator's apprentice, if you will, but they really were not accustomed to playing the role of counselor or advisor. Let's step back from this a minute to just look at the problem so you have some context. The problem about which they write the letter in my class is something that's easy enough to understand. Some of you may have run up against it with children or relatives. The age 19 rule in high school sports. Every state that I'm aware of has a rule that says if you reach the age of 19 before a certain date, which is usually July 1st, August 1st, or September 1st, you are not eligible to play high school sports anymore. And this is a particular issue with learning disabled students who are often held back more than once. And if you're held back once, you may be able to get over the hump here. But if you're held back twice, you're likely to bump up against this rule. And the really sad part about it is you tend to be held back because the educators haven't discovered your disability, not because of anything you did or failed to do. And the other difficult aspect of this is for these kids, very often sports is the first success they've had in school. And it's a major means of socialization. So you're really taking something very valuable away from the child. On the other hand, the school district has some serious concerns: competitive parity, safety of younger players, especially in rural areas where you might have, you know, a 14-year-old freshman playing on the varsity team. Do you really want the big muscular 19-year-old playing with him or her? And you also don't want to encourage parents to say, well, let's hold Johnny back so he can get big and strong and then, you know, be a dominant player in his senior year. As far as the courts are concerned, there's a split of authority as to how to treat this. Some courts regard the age cutoff as an automatic exclusion, and if you reach the age of 19 before the operative date, you are automatically excluded. In other words, they don't view waiving the age requirement or waiving the age limit as a reasonable accommodation. Other courts will give you an individual assessment. You get a little more due process in some places, and will give you an individual assessment to determine if that individual student would cause safety problems or competitive parity problems, etc. So there's a split of authority on how to treat this. The immediate problem is illustrated in the handout. It involves a student who is hearing impaired as a result of meningitis. She started school late and then was held back another year, and now is 14, but her parents are very savvy. In order to make the problem work, I had to make the parents savvy, because the parents have figured out that 5 years down the road, she's going to bump up against this rule. And the parents are educated folks, and they're thinking ahead, and they come to you and say, what can we do about this? And I didn't want to create a situation where the only option was litigation. I wanted to create a situation in which the students would consider short-term options well short of litigation. So they would consider a menu of options. And you can read the handout for more particulars on the problem. I realize my time is limited. Let me just talk then about the benefits of the exercise. At first blush, as I said, I thought it was very helpful to get students thinking of themselves in a different way rather than as, you know, just sue the bastards. And in the first year, that's exactly what happened in a number of instances. Some students, just litigation, you know, go get them. And I thought, wow, I guess I have to make this point better. Just like with the emails, you assume that they know something, but not everybody did. And even in the case of some very good students, boy, they were primed to go to court. And so what I wanted them to get to see, and over time I think they've gotten better at seeing this, is the short-term options. In this particular problem, one of the options available is go to the school and persuade the school to consider putting sports in the student's individual educational plan, which is going to make it much easier if you ever have to go to litigation. So that's the first step. I set the problem in Missouri because Missouri has a rule that says if you're going to have this kind of problem, we can make you eligible to start sports in 8th grade. So you can participate 8th through 11th grade. That doesn't help you in your senior year, but at least you get to play 4 years like everybody else. Private school is an option in some instances. Right? So these are things that really don't have anything to do with legal analysis necessarily, particularly the private school and the starting sports in the 8th grade, but they do force the students to think outside that usual realm of, okay, I file a complaint and I go after it. And that's exactly what I wanted them to do. In fact, it even got one student. This scenario is a runner, involves a runner, and even one student who had run cross country and track said, well, this is easy. Why don't we just go to the school and talk to the principal and the coach, and then we can talk to the state high school association. You can have somebody who's not eligible still compete, and they just wear a different color shirt, or they don't run through the chute. And that may seem like pretty basic stuff, and it's a lot more about sports than law, but as a lawyer, you are called upon to be able to understand the context in which you work, and that might solve the problem. And if we want students to be problem solvers, we do want them to think about those kinds of things rather than just citation form or Westlaw or something like that. All right, so I also happily discovered that each part of the letter has a benefit. And let me just run through those quickly. There's value in the greeting and the introduction, and not only so that they'll know how to write, dear Mr. or dear Ms. But it forces them to think about how to develop a rapport with the client. You don't want a letter that starts, responding to yours of December 17th. That's dreadful. You might do that for the in-house counsel of, Amalgamated Zipper Corporation, but you don't want to do that when you write to a client who's not an institutional client. It also helps them think about how to deliver bad news. These are, and that's why I make it a problem where it's parents and a daughter. I mean, what could be more emotional than that, right? So you want to teach them to develop a rapport with the client, and the greeting also forces them to think about who's my audience. Who am I writing to? Am I writing to the in-house counsel? Am I writing to Professor so-and-so, or am I writing to somebody who's a working class person? And what's my purpose? And of course, that should force you to adjust the language somewhat to the audience. Now, then you go into a discussion of facts, and of course, there's value there too. And particularly, I urge them to state at the end of the facts section and at the beginning, this is my understanding of the facts. If you understand the facts differently, please contact me and let me know. And try to point out to them that not only are you doing a service to the client there, you may be protecting your own backside, because you want to make sure that you don't go to court arguing something that's based on inaccurate facts. And it also, I think, shows the students the need for objectivity. Yeah, to some extent you certainly are their advocate, to some extent you are their champion, but you also need to have the objectivity that's required for professional judgment. Then the analysis section illustrates, I think, a very important point, which my students hear entirely too often, I think, from their perspective. If you can't explain it to an intelligent layperson, an intelligent non-lawyer, you don't understand. And so the analysis section has that beautiful benefit. It forces the students to understand it well enough to explain it in language that a non-lawyer can understand. As you would imagine, I never make the recipient of the letter an attorney. I try to make them professionals, to ease the task a little bit for the students, so they don't have to lower the temperature of the language too much. But I also don't want them to be citing cases and talking about statutes. And then the advice and recommendation section forces them to be problem solvers. And maybe the problem can be solved by talking to the state association and having the student run outside the chute. My God, you'd love it if every problem could be resolved that way. But there may be a creative solution here, and you want them to present a menu of options. They can include a recommendation. I think under the circumstances, this is the best choice, but here are your options. And then the closing forces them to think about, forces the lawyer as well as the client to think about next steps. What are we going to do next? Here's what you will need to do if you want this process to move along, and here's what I can do for you, and get back to me and let me know how you want to proceed. So I think, to quote some of my old college political science professors that from years and years ago, that the client letter is really enlightened self-interest. I think it really helps the client, does a great service to the client, but also is not only covering the rear end of the lawyer, but also a great advertisement for the lawyer. If you write a nice, clean, crisp, well-crafted letter, there's no better advertisement that you could put out. So I hope that in our rush to develop new methods of making our students' practice ready, that we won't forget an oldie but good. Thanks.